Imagine this. You have paid 75 lakh rupees for a property, stamp duty is also paid, an agreement is signed, power of attorney is also given. Now the big question is, have you legally become the owner of the property? Not necessarily. Because in property transactions, agreement to sell and sale deed are not the same thing. An agreement to sell is only a promise between the buyer and the seller. It says that the seller agrees to sell the property and the buyer agrees to buy it on agreed terms and conditions. But this document by itself does not transfer the ownership. It gives the buyer a contractual right. That means if the seller refuses to complete the transaction later, the buyer can take legal action and ask the court to enforce the agreement. Now let us understand what the sale deed is. A sale deed is the final ownership transfer document. When the sale deed is properly executed and registered, the ownership of the property legally moves from the seller to the buyer. So remember this simple line. Agreement to sell gives you the right to buy. Sale deed makes you the owner. Let me give you a practical example. Agreement to sell is like booking a flat or confirming a deal. Sale deed is getting the final ownership document. Until the sale deed is registered, the seller may still remain the legal owner in records. Now you may ask, why do buyers and sellers enter into both the agreements? Because in many property transactions, everything is not completed on the first day. Title verification may be pending, land measurement may be pending, permissions may be also pending, payment may be made in stages, legal heirs or family consent may be required, and in the case of agricultural land, revenue permissions or compliances may also be involved. So, first, parties enter into an agreement to sell to lock the commercial terms. Later, after all the conditions are fulfilled, they execute the final sale deed. Sometimes a power of attorney is also given, especially when there are many sellers or when the sellers cannot remain personally present before the sub-registrar or the government office. But be very careful. A power of attorney is not ownership. It only gives authority to act on behalf of someone. It cannot replace a properly registered sale deed. So if you are a buyer, do not rely only on the agreement to sell or power of attorney. Check the title, payment proof, stamp duty registration, TDS compliances, possession clause, and final sale deed. And if you are a seller, clearly mention the payment terms, default clauses, possession date, tax liability, and cancellation clause and refund conditions. The biggest mistake in property transactions is assuming that signing an agreement means ownership is transferred, but it's not. So before signing any property document, remember this: agreement to sell is a promise. Sale deed is the ownership. This one difference can save you from a major legal or financial dispute. Share this with somebody who is in the process of buying or selling a property.